seated.
Good morning, everyone, and welcome to a morning session of oral argument in the 5th District Court of Appeal. As you've already heard, I'm Judge Griffin. To my right is Judge Orfinger, and to my left is Judge Lawson. We have a fairly complicated docket today with cases coming on and going off, but we've ended up with 4 for today, which we will take in order. Some are criminal, some are civil. I think you already know that in the criminal cases there's 15 minutes of argument per side. In the civil cases there's 20. For those of you unfamiliar with the procedure, there is a clock on the podium for you to keep your time, and if you'd like help with time for rebuttal, let me know and I'll see what I can do. We'll call the cases in order. The first one is Jose Pagan versus State of Florida, and it appears everybody's ready.
Good morning. May it please the Court, I'm Jeffrey Dean. I'm the Regional Conflict Counsel. I represent Mr. Jose Pagan in this matter, a matter about his sentencing. Your Honor, before I get started, I would like to reserve 7 minutes for rebuttal if I can. Right. Thank you. Mr. Pagan has been sentenced as a PRR to life in prison. That's clear from the record. It's my contention and our contention for Mr. Pagan that this is the kind of thing that happens when there is no discretion allowed in the court and the prosecutor runs the courtroom. This is not the kind of thing that should be happening in our courtroom. The reason I say that is because I know that you're going to tell me that this is well-settled law and the prosecutors have the discretion in a courtroom, and what they do to charge a case is not the business of the court because they can bring charges anytime they would like to do that. This is not that, and I would submit to the court that there has to be some kind of line somewhere that changes the course of conduct in a courtroom by the prosecutor from being arbitrary and capricious in a decision and doing something because he can and exercising the discretion that's invested in the prosecutor's office. Mr. Pagan's case, when you look at the facts, I've said this in my brief, I've said it in the record, I'm going to say it one more time so that this court doesn't believe that I'm suggesting that Mr. Pagan shouldn't be punished for his actions as committing a robbery. He did. He committed a robbery. But when this court, in a clinical setting, looks at his situation in the context of all the other, I'm going to say robberies, this is not the kind of case that would ever receive a life sentence. All the objective indicators in this state that I can find indicate that he would not get a life sentence. His sentencing guideline score sheet recommended a maximum sentence of just over 7 years. His low end on his guidelines was just over 5 years. That would be his sentence. In the record, there was a lot of discussion about Mr. Pagan's prior record. The case law that I've cited for the court has indicated that Mr. Pagan's prior record is not a violent prior record. And so where we're at is we look at the objective things that we can find, and then we decide, and I think that the courts have directed this court to decide whether or not Mr. Pagan's sentence is grossly disproportionate to what he would have, to what other people have gotten in like or similar circumstances to him. This is a grossly disproportionate sentence. Mr. Pagan's prior record points are 21.7, I think. His prior record consists of some felonies. The qualifying felonies for him that made him qualify for PRR.
Are you supposed to, maybe this is academic, but of course, because of the PRR statute, anybody in a similar circumstance has a mandatory life sentence. So in that sense, it's absolutely proportionate to anybody in a very similar circumstance. You're asking us to assume that the PRR statute isn't there and ask what the sentence would be and do a proportionality analysis based on a sentencing laws that didn't include this statute. That doesn't.
Actually, I'm not, Your Honor. I think that the point I tried to make in my brief about that, and the fact is that I believe the case law says to you, you don't have to ignore the PRR statute or any minimum mandatory, any minimum mandatory sentencing scheme. However, available to every defendant is this last, I guess it's the last thing that they get, is a proportionality review of their sentence. One of the cases I cited in my brief, which is Henderson versus Norris, deals almost directly with that. There is in that case, the defendant in that case was under a minimum mandatory sentencing scheme for drugs. In that case, and this has been, I think, widely settled, that you're allowed to go back and say, and in Henderson they actually compared it to the guidelines they were using, which was a U.S. Supreme Court case in which they compared this mandatory sentence that was being imposed in Henderson to the one that was their guideline in the case Harmelin versus Michigan. And they were comparing. In Henderson it was this amount of drugs, in Harmelin it was this amount of drugs, and they went through the analysis, a proportionality analysis. That's actually what you get to do. And I'm not asking you to ignore it, but what you are allowed to do is to say, and I think it also begs the question, but what you are allowed to do is to say, he's a prison releasee reoffender. However, where do you get to say that every one of them qualifies for this harsh sentence? And that's the last check on this sentence that there would be. Otherwise, I would submit to you, otherwise, there would never be a reason to have a judge. There would only need to be ministers. And I think, Your Honor, if you go with the premise that you just suggested, that would violate the doctrine of separation of powers, because then there would be no function for the court whatsoever. And so I think that would clearly violate it. I would make an argument about that later, but I think if there's no final say in the court, then that clearly is a violation of the separation of powers doctrine. But the case law provides the guidelines for you to follow this, even under a minimum mandatory sentencing scheme. In Henderson and in Hale, in the case law for Florida, they all start with for a sentence that has a term of years, they all start with the premise that the sentence has to be grossly disproportional. There's let
me just stop you there. I mean, to me, a violent and serious felony, if you stick a gun in somebody's face and rob them, which is what happened here, with a history of serious felonies, although not, I mean, they are serious felonies, they may not be violent, that just doesn't strike me as being grossly disproportionate to the kind of sentence you would see for other violent, serious felonies with a history of serious felonies.
The track that the court has suggested that this court would follow would start with grossly disproportionate as the standard, and then there's a way to come to that and to decide whether it actually is. Because if you start with the premise that it's a robbery, all robberies are bad, and I'm not going to say that they're not. But I think that what the court would require and what the case law suggests is that you would start with all the robberies. And it's the same thing as saying if you stole $1 million, that's theft. If you stole $5, that's also theft. But that there should be some difference in that. And so the first thing that you would do is compare the gravity of the offense, as you find it. And I think you have to deal with the facts of this robbery compared to all the other robberies. Judge, there's no but for this PRR statute with a gentleman of this record, with this prior record, there is virtually no chance. I would suggest to you there is virtually no chance this man would be sentenced to life in prison under any circumstances. Yes, ma'am?
That's your time.
Okay, thank you. I'll reserve the rest. Thank you very much.
May it please the court, I am Carmen Corrente representing the state in this appeal. Just briefly, I would like to point out that at the end of the day here, this was a very violent crime. This was as much the maximum you could do in robbery without having some other crime. If he had fired the gun, if he had struck the victim with the gun, we would have other charges. This is armed robbery. This was a planned armed robbery. It was brazen. It was in daylight, in a crowded, I assume crowded, but in a mall, a major mall, outside Macy's, where the theft took place, ran through the people, had a getaway car. That car drove recklessly. That car crashed into several other cars. A gun was thrown out the window. A stolen gun was thrown out the window. And the state feels that this is one of those crimes that deserves a life felony. The armed robbery is a felony punishable by life. And there is no disproportionality in this sentence. A violent crime is violent or has the threat of violence. This one had all of that. And while his history was not violent, up until now it wasn't. Now it's escalated. 11 months after getting out for drugs, he is committing violent crimes to get more drugs, apparently. So the state believes that the sentence was fair, proportional, and constitutional. And unless there are any other questions, we would rely on our brief. Thank you.
What Mr. Correnti says is correct. This was a robbery. But the point of this is that you can say that every time, but this state has assigned a value to every single thing that was described by the state in its brief argument. This all has a value. This was a level 9 felony. It's scored as a level 9 felony. What he did has a value. His prior record has a value, and it was scored 21 points. That has an objective value. The reason we have the guidelines is simply because we get away from, in place to place, that what's serious to you may not be as serious to the next judge or as important to the next person that argues it. These all have values, and all of the values that are assigned to exactly what Mr. Pagan did, not mitigating it at all. They all have values that fall way, way, way short of a life sentence.
If the PRR statute didn't exist, what would have been the maximum sentence the court could have imposed anyway?
Judge, he could have gotten life as a maximum sentence.
So if the court had imposed life, how do you square a proportionality review? If the argument now is, we don't even have a PRR statute, but my guy got life and he only scored 21 points, and here are the records of 100 other robbers across the state that got 10 years, 15 years, whatever. If we say that, as you argue, that things have a value, hasn't the legislature made that value decision that even in the absence of a PRR designation, the potential value, legal sentence, which would be unappealable generally speaking, would still be life?
Judge, I think there is a giant difference between what someone can get and what is optional for a judge to exercise its discretion on in its court, to the mandatory decision of a prosecutor to classify this as something and something else as something else. That's the big distinction. Whether or not you can do it doesn't mean you should do it. And whether or not it's possible doesn't mean it's practical. Mr. Pagan was deprived of every single opportunity to mitigate his case. If Mr. Pagan had gone to court, had no PRR, every other guideline for every other judge is he may be sentenced, and in one instance he would be sentenced to a 10-year minimum mandatory under the 1020 life. Every objective guideline that would guide a court, every one of them, points to something far less than life. And Judge, to answer your question specifically, if after hearing all of that, all of the facts, all of the mitigation, putting all of the factors in play that are erased completely by the fact that we have basically the prosecutor picking low-hanging fruit here and sentencing it grossly differently than all the other people that fall in Mr. Pagan's situation with a record and facts of his case that look like this, if that got life, then he would do life. But quite frankly, Your Honor, I would again say to you, there is virtually no chance this man would have gotten life other than the fact that this judge had to do that. There's no chance of it. My experience tells me that. I think that in your courtroom, your experience is going to tell you that. Every time you're going to deal with a life sentence, you can look at these facts and compare them in your own jurisprudence and say to yourself, does this qualify for life or does it not? This situation, Mr. Pagan is going to prison for the same thing that the guy that didn't get the death penalty is going to go to prison for. Those facts are grossly disproportionate. Judge, to go back to your original question, the Henderson case actually takes you through this analysis in which it compares two people that are under penalty for a minimum mandatory drug sentence that got life. One had 600 grams and one had 5 rocks. In that case, in the Henderson court, that they did the analysis that I'm asking you to do, and under every criteria, they found that Mr. Henderson didn't qualify for life, like the large quantity of drugs. And in that case, I would point out to you all, in that case, they looked. One of the guideposts was the defendant's sentencing guidelines.
Let me just stop you really quickly. There's not much time left, but I also feel very uncomfortable given the very limited nature of the record. I mean, you put in a few sentences from a few people, but I mean, I can imagine that there are hundreds, thousands, maybe tens of at least thousands of people in the Department of Corrections on this similar charge.
They're not.
They're not.
No,
Does the record reflect how many are there or how many are
Judge,
not?
we subpoenaed the Department of Corrections. What we actually did was try to follow the PRR statute and subpoenaed the state's attorneys' offices for their records that they're required to file when they don't exercise their discretion in filing PRR. We couldn't even get that. And then we tried to backdoor it, and we asked...
Is all this reflected in the record?
It is, Your Honor. Okay. It is. Finally, just briefly in the half a minute I have about the separation of powers, I just want to reiterate again, and I know you're going to tell me that this has all been settled by Cotton, but the Cotton decision came in the year 2000. The Martin decision in my brief came in the year 2005. I think it adds clarity to what the Constitution requires by the Florida Supreme Court to avoid invading the separation of powers doctrine and the non-delegation doctrine. That case simply is a better roadmap than the much earlier case of Cotton. Thank you very much.
Thank you, Mr. James.
Thank you.